Okay, it is 2:05 now, so let's get started. Housekeeping things. So first, my name is Laurie Steiner. I'm a partner at the law firm of Solomon, Steiner and Peck. And my topic today is parenting your parents, personal and estate planning considerations. So this is meant to be sort of an overview. I'm not going to be able to have time to get in depth with any one of the topics we're going to cover because there's a lot of things, just to kind of give a broad overview of issues spotting, I guess, thinking about things that have to be taken care of, so that you can talk to your family, your parents, your children, however it is that your family is situated, to make sure things are going well. Plus, it's also part of what is elder law. I'm an elder law specialist. I'm certified with both a federal organization, a national organization, and the state of Ohio. So these are the kind of things we look at when we're dealing with our clients. It's not just estate planning. It's not just one thing. There's a lot of stuff that has to be thought about as you age. So that's what we're going to be talking about today. If you have a question along the way, everybody's muted, so nobody can talk over each other. So I won't know if you have a question unless you put it in the Q&A box. On your screen, you should see like two little text messages next to each other and Q&A under it. Go in there, and if we type your question, I'll be able to see it and I'll be able to respond to it live, hopefully, if we have the chance, or at least respond to you by text later on if I have to. So with all that being said, I'm going to get started. So I am going to start on the first slide here, parenting your parents. So that's me there at the bottom. And if you have any questions later on, or you want to call the office and say, hey, I need to do this stuff, then that's the contact information for you. So we're going to start out first with what I said. What is estate planning? And this is a big part of elder law and planning for your parents or yourselves, and even for children or grandchildren to think about. It's not all you have to worry about as you age, but estate planning is something that most people understand. What that is it's a way of providing for yourself and your family for the future. You want to try to have everything in place, help your family not have a big hassle, not have a lot of questions, not have a lot of problems at your death or your incapacity. So it's organizing your personal legal affairs, trying to protect your assets, provide or pass them without probate. Also to save taxes if that's possible at the time of your death. So it's an overall more financial looking process. It is not a static process either. You can have estate planning documents in place, like I have listed there. Everybody needs a last will and testament. Everybody needs a durable financial power of attorney. Everyone needs a healthcare power of attorney. Everyone needs a living will declaration if you are of the mind that you don't want your body to be kept alive when there is no hope for you. You're really not there anymore. And sometimes you need a trust agreement. Depends upon how you want to leave your estate and how complicated your assets are, and if you have a business or not, and so many factors. So everybody needs to have these documents in place. I'm going to talk a little bit in more depth about the wills, the financial and healthcare power of attorney and living will. The trust agreement is kind of a step above this basic overview. And that would be something that we would talk about at an actual meeting to plan what's going to happen in the future and determine whether or not we can meet your needs and wishes with the least cost and fuss without a trust, or if that's the only way to do it. And my last point on that page, there's also a more of a life care planning component to elder law. So that's as you age, things change. Just like as you age, you might have to update your documents because they're not going to reflect what you want or need anymore. That's all part of this. As you age, where is the best place for you to live? Most people want to stay at home. So there has to be a look from a health point of view. Is that possible? And then if it is possible, do we need to have in-home help? If it's not possible, where is the right place as you age and get more ill or have dementia or Alzheimer's or any of these other problems, is there a better place to live? Is there better care that can be provided? Is family in town? Is family not in town? So it's trying to get the financial piece in place, but also the personal piece in place so that everything meshes and you have the best possible life from beginning to end. One of the things I mentioned earlier on part of estate planning is how to avoid probate. That's one thing most people have asked me every time someone comes in. Well, I've heard you got to avoid probate, or I've heard you have to have a trust agreement to avoid probate, and don't even understand what probate means. They've just heard it on some talk show that it's the thing to do. So I wanted to hit that first because it's one of the most common questions that I get. So the probate court, what that process is when you need probate, assets are gathered up by the executor. So the executor is named when the will is filed with probate. And the first job of the executor is to find out what assets are in this probate court process. The assets that go through probate are only assets that are in your sole name on your date of death. It's just you. Because it's just you, the bank or the financial institution has no idea where that money is supposed to go to. They just have no idea. It's just in your name. So that's why probate court is needed on those kinds of assets. It's solely owned assets on your date of death, which the executor has to inventory and present the inventory to the court. The will has been probated, so that's how the executor was appointed. The executor is responsible to pay any bills. If there's any estate taxes or income taxes for that decedent's estate, they have to be paid. And then the court reads the will basically to see who the beneficiaries are in order to say, well, these are the people who get it. So that's when the remaining assets are distributed and an accounting has to be filed. So it's kind of a hassle. It's a long process. Can cost money, and it's public record. I think that's one of the biggest things people don't like, is that anybody can go down to probate court, pull your file and see what your assets are and who got them and how much your funeral cost, because that's something that you have to prove was taken care of, or else it has to be taken care of during the estate process. There are other ways to avoid probate, and most people that we meet with do want to avoid probate. So ways to avoid probate. One thing is a trust agreement. Like I said, some people need it, some people don't. It depends upon how complicated your estate is. It depends upon how much control you want over your assets after you die. It's really the only way that you can control things upon your death, because a trust can outlive you. It can provide terms that allow assets to be paid out immediately or over a period of years, or be held in trust for the lifetime of the beneficiary, or different types of trusts. If you have a child who has special needs, or someone in the family with special needs, and you want to provide for them, then it has to go into a special needs trust or a supplemental needs trust, kind of the same thing. So there's reasons why a trust is important, but not everybody has to have a trust. You can also title your assets joint and survivorship. That makes the most sense when it's between husband and wife, because usually that's where you want your assets to go. And if it's joint and survivorship, both parties own that together. It's not necessarily as great to have assets titled joint and survivorship with parent and child, because that means the child is an owner on that asset and could close out the account and take the money, or maybe not that so much, but they can also have, let's say, a mom and a son are joint in survivorship on a bank account, and the son gets into credit or other kinds of financial trouble, and they're looking to attach that child's bank accounts. Well, the bank accounts have mom on it too. And a lot of times mom's money is what's in there. It's just joint and survivorship to avoid probate. But if the son has issues and he's an owner on that account, they're going to come after that account too. So that's the same if you've got a joint and survivorship on the house or other investments. So sometimes joint and survivorship isn't the best way to avoid probate, but Then we get into things like POD, which is payable on death, or TOD, which is transfer on death. Titling those assets in that fashion so mom would continue to own it. She just puts her son on there, payable upon death to my son, or transfer on death to my son. Depends on what kind of asset you're talking about, which of those two that you use. But that's a little safer for mom's money, because if the son does have a bad lawsuit or a car accident or something and they're coming after him, they can't come after mom's money because it's not his yet. Also, there are certain assets that you actually have to name a beneficiary. Those are IRAs, annuities, life insurance. Those aren't really payable on death or transfer on death. They are actually a beneficiary designation, and that will avoid probate because the bank or the financial institution or the life insurance company knows where the money is supposed to go. So when we're talking about avoiding probate, it's really a big part of that is how you title your assets and making sure they're done correctly and you don't forget anything. Now, if you do forget like one bank account and it has to go through probate, that doesn't mean everything has to go through probate. So you just try to catch everything. Probate is a fallback in case you've missed something. So the will controls what goes through probate, as we talked about. So you got to have a will, just in case anything does go through probate, even though you're trying not to have anything go through probate. So talking about that will, as I said, the will doesn't avoid it, it controls it. So a will, if you break down what it really does, it's a document signed by somebody, that's the testator, that's like you, setting forth who's in charge at death, that's the executor, and where the assets go, that's the beneficiaries. So you got to have a will, even if you don't think you're going to go through probate, just because something might slip through the cracks. So a will is really important, and it's oftentimes the only document I see a client have when they come in to meet with us to discuss their estate planning documents. It's not the only document that you need. Okay, little bit that has to do with wills and dying, at least for estate taxes. There are gift tax rules and estate tax rules, and a lot of people don't understand how they work. So I'm going to give you a little primer on that. This is not everything you need to know, but it's at least will maybe help you understand how they work, especially in Ohio. Ohio has no gift taxes. Ohio has no estate taxes. They repealed the Ohio estate tax a number of years ago. So what we're dealing with always in for gifting and for estate when you die is federal law. So for gift taxes, people all seem to know that you can give up to $15,000. That's the current annual exclusion gift amount. $15,000 per person per year, and there's no gift tax consequences. No return to file, no taxes to pay, nothing. It's simply just money being given to a child. So if you're in a married couple and you have one child, mom can give $15,000 and dad can give $15,000. So a total of $30,000 when it's a married couple. But that's not all you can gift. There's also something called the lifetime exclusion amount, or the gift. Currently, that lifetime exclusion excluded from paying gift taxes is $11.58 million per person. And that's over your lifetime. If you give $15,000 a year, every year, it just doesn't count towards anything. If you give $100,000 1 year to a family member, the first 15 is the annual exclusion amount, and the rest goes against this lifetime exclusion amount, so that for most people in their lifetime, they will never have to pay any gift taxes, because I don't have a lot of clients who have $11.58 million that they want to give away to begin with. And even if they did over time, most people don't have that kind of money. The difference between the $15,000, which requires no gift tax return, no reporting, no nothing, and you start getting into your lifetime exclusionary gifts, you have to file a Form 709. That's a federal gift tax return. But you don't pay any gift taxes. As long as you're not over $11.58 million in your lifetime, you pay no gift taxes. Now, if you're lucky enough to have that much money and you choose to give it away, Gifts are taxable at a rate of 34 to 40% on the amount over the 11.58 million. So it's expensive to make gifts that large. Now, the gift taxes are integrated with the estate taxes. So this lifetime exclusion of that 11.58 million per person excludes gifts that you make, or it excludes also when you pass assets at your death. So you might have made gifts during your lifetime, and then when you die, as long as the total what you gave away during your lifetime and what you are passing at your death is not in excess of that 11.58 million per person, you won't have any estate taxes to pay. So if you do, though, if you have really large estate, you have to file this federal estate tax return form 706, and the rates that you pay federal estate taxes is the same as the gift rates because they're integrated. So you've got this 11.58 million you've got to give away during your lifetime or pass at your death with no estate taxes. Now this could change if we have a change in the presidency, change in the government wanting to get a little bit more money back in. It was changed. This exclusion was increased, doubled basically. And it could go back to half of that again, but still it would be 5 or 6 million per person, double that for a couple. So a lot of people still won't be caught by any kind of gift taxes or estate taxes. Okay, now I mentioned the will already, but I also said there were some other documents that you need. The will is mostly used, well, it's only used when you pass away. But if you have issues while you're alive, you need other healthcare and disability planning documents. So in this case, we want to avoid a guardianship. That means you're alive, but you're not competent anymore. And you've got, if you don't have documents naming somebody like your durable financial power of attorney or your healthcare power of attorney, you've got nobody named and you're incompetent, that's going to mean that you've got nobody to help you. And then the only option for someone to be able to take care of your affairs, financial and health-wise, is to have a guardianship, go to court and apply to become your guardian. Again, it's being in probate while you're alive. It's no better than, having it after your death. So we try to avoid a guardianship and having a probate court making decisions for you. It really takes away your individual rights and says, you're no longer competent. You can't decide anything. This guardian then has to make decisions for you, but has to get the court's approval. So there's lots of hearings, there's an inventory at the beginning, there's accountings, there's hearings to ask the court's permission to spend money or to make certain medical decisions. So we want to avoid all that too. So for that, I already identified you need a financial power of attorney, healthcare power of attorney, and a living will. Really, those are the 3 disability documents that are only actually used while you're alive. They die with you because they're no longer good at the time you die. So for financial power of attorney, somebody else can take care of all your financial affairs. The word durable is actually important. Durable means that the power of attorney is still valid even if you become incapacitated. Now that sounds like, well, of course, that's when I need it. Why would it not be effective when I become incapacitated? A long time ago, they weren't. They were just effective only as long as you were mentally effective to make your own decisions. It was just adding on somebody who could do it too. I had a lady who her husband was ill. He was incapacitated in a nursing home and she came in to do some planning for him. And I said, okay, well, do you have a financial power of attorney for your husband? And she proudly brought out a document and handed it to me. It was a power of attorney drafted and signed when her husband shipped off to World War II. At that time in this world, financial powers of attorney were not durable. It didn't work if you became incapacitated. And she thought she had everything done, that he had done that for her when he went to war. And I said, I'm sorry, this isn't effective now. There's nothing you can do under this because he's not competent anymore. And so it turns the powers off. So that's an example of, this is not a static planning process. You have to update your documents from time to time. especially the financial power of attorney. The laws change, the bank willingness to accept a certain power of attorney with or without certain language changes. That's the most updated document that we do. Financial durable power of attorney, probably every 3 to 5 years, we would recommend that be looked at and changed as necessary to comply with all the new rules and regulations that come into play. If it doesn't include certain bells and whistles, it makes it very difficult to undertake some of these subsequent planning, like planning for VA benefits or planning for Medicaid benefits that need to have, if you're not competent, you need to have somebody else who has the ability to change your accounts, close accounts, transfer assets, open new accounts, all kinds of things. So that document is really important. Then there's the healthcare power of living well, healthcare power and living well. Healthcare power of attorney is naming somebody to make your medical decisions, from simple ones all the way to end of life choices. The living will supplements your healthcare power of attorney. The living will is really a document you're signing, putting in writing your choices at end of life, so that they are in writing in case you can't express them. And your healthcare power of attorney can see what you said in your living will when they're making medical decisions to know whether or not you wanted to be kept alive and hope for a cure, or if you wanted to be just let go peacefully if there's no hope for you, and not to be hooked up to all the machines. So those two documents go hand in hand. And you should have both, especially if you feel strongly about not being kept alive. If two doctors agree, there's really nothing that they can do. All right, so I'm going to shift gears a little bit to how to pay for healthcare. Not yet necessarily long-term healthcare, but how does Medicare in general work? So Medicare is the federal health insurance that most people get if you worked in the Social Security system. Unless you're disabled and able to qualify for Social Security disability and Medicare early, it starts at age 65. So even if you don't apply for Social Security at age 65, you don't wait until your full retirement age or 70, you still have to sign up for Medicare at age 65. So Medicare is mostly just for health insurance. It is separated into these parts. So traditional Medicare has Part A, which is typically, since you worked in the system, that part is free. And Medicare Part A covers hospital bills, some skilled nursing facilities, which I'm going to get into in a minute. It covers hospice if you're at end of life and likely to die from whatever that issue is within a 6-month period. And it pays for some skilled home health care. Then there's Part B of Medicare. Part B is what typically you pay a premium for. This year, the premium for Medicare Part B for most people is $144.60, and that just comes out of your Social Security check. And Part B covers doctor services, outpatient, home health services, x-rays, blood work and all that kind of thing. Then going down the line with traditional Medicare, if you've got A and B from the government, A and B only pays 80% of the medical bill. And then there's this 20% that either you have to pay out of pocket or you have a supplemental health insurance policy. With traditional Medicare, you have A and B, and then you have to buy a supplemental. It could be AARP or Medical Mutual or Blue Cross, or there's all kinds of them. And that's what open enrollment is all about, which we're just hitting open enrollment this past week until through early December, that you have to look at your supplemental insurance plan and make sure it still fits what you need and want for the future. It covers your prescriptions, it covers your doctors. And you can change how that's set up and change your plan on an annual basis. So again, with traditional A, B, supplement, and then Part Part D is the Medicare prescription plan. And those you can change on an annual basis as well. Some people, though, have something called Medicare Advantage. Medicare Advantage is the government has certain insurance companies that contract with, and you go into a Medicare Advantage plan with United Healthcare or CareSource or Buckeye, Ohio, or other Anthem. There's a number of those. The benefit that people see in Medicare Advantage is that $144 a month premium, which pays just Part B in traditional Medicare, and you have to pay out of pocket for supplemental and for prescription. In an Advantage plan, that $144 covers A, B, supplemental, and D. And in the rules, it's actually called Medicare C. Medicare C is the Medicare Advantage plans you hear a lot of, and the government pushes those because they are cheaper for the government to run. They don't have to pay out as much money. It's up to people's choices. Medicare traditional with the A, B, supplement, and D are nationwide. You can be in any state because the federal government paying for it, any state, and have coverage. The Medicare Advantage is more like an HMO, which means it's local. You can only see the doctors in your home listing of doctors. And if you go to another state, it won't pay for traditional healthcare. It'll only pay if you're in the emergency room or something. So there's choices there that have to be made. And it's actually something I recommend my clients go see a specialist in Medicare. I have some people that I refer my clients to who have to make choices about Medicare every year, or even when they're just signing up. And it's so complicated in a different way. I'm only scratching the surface of it, and I'm not qualified to give advice on which plan is the best for me or for you. As far as nursing home coverage goes, so if you become ill and have to go to a nursing home, Medicare only pays for a certain amount of time for certain reasons. For a nursing home under Part A, Medicare will pay for 20 days in full, and then there's an additional 80 days, so a total of 100 days. But the 80 days, you have to pay $176 a day unless you have supplemental health insurance or a Medicare Advantage plan that's covering this particular facility. And it only pays if you're in the hospital admitted for at least 3 days, and then you're actually admitted. You're not under observation. Observation is outpatient, and even a 3-day observation won't get you Medicare coverage in the nursing home. You have to have an admission for at least 3 days and go straight to the nursing home for therapy. The nursing home has to be Medicare licensed, and the bed has to be Medicare certified. Most skilled facilities, they're going to meet those requirements. It's just that you've got to know that you were not just under observation, that you were actually admitted to the hospital in order to obtain that coverage. So it gets complicated, and if you have an illness or a disability, stroke, broken hip, things like that, which would mean you go to the hospital and then you go to the nursing home. So Medicare doesn't pay very much of nursing home care. If you get your full 100 days and you have to stay in, you don't get more days unless you start the cycle over again. So paying for long-term care, that's always a concern as you age. I want to stay home. I don't want to be in a facility. So what are the options for maybe staying home, and what are the options if you end up having to go into a facility? So first off, and what most people end up doing, at least with a good part of their money, is self-pay. There are also ways to work out rental and care agreements with children or others, and I will go through that a little bit more in depth. There are some veterans benefits I'll go through. Some people have taken out reverse mortgages, and we'll talk about that. Finally, there's private long-term care insurance. Medicare, as I said, doesn't pay very much for long-term care, and then there's the Medicaid program. So I'm going to take a look at each of those. So trying to stay home is these 4 areas typically. So rental and care agreement. So what does that mean? Sometimes we have children moving in with a parent and providing care. And if that child moves in with you, you can pay them for the care that they are providing, as long as it's under the terms of a written care agreement. Sometimes a parent moves into a child's home and to get the same kind of care, and they just can't stay in their own home anymore. And in that case, you can move into your child's home and pay them rent for living there, proportionate to what part of the house that you're using. And they can provide you care, and you can pay them for that. How that is a way to get a child or somebody else in the family to take care of you at home and prevent a move into assisted living or a nursing home. It is also a way to pay money to a family member who's going to turn around and use it for you later if you need it. For Medicaid, as we're going to talk about in just a bit, you have to have very little in the way of assets. So a rental and care agreement can work with a future Medicaid application as a way to reduce your assets to your children, where you want them to go anyway, and have your children hold on to them and use them later on for you when you don't get to have any assets when you're qualifying for Medicaid. So it's just an option for staying at home, and it can work to get Medicaid later, or it doesn't have to be that way either. Veterans benefits, obviously there has to be a veteran in the family. There are lots of World War II, or is it less and less these days, more Korean War. The veterans benefits I'm talking about is called the Aid and Attendance Special Pension. In order to qualify, the vet has to have had at least 90 days of service, 1 day of which was during declared wartime. So it doesn't help everybody. But what most people don't understand is the veteran can get benefits, but if the veteran passes away and has a surviving spouse, the surviving spouse can get benefits as well. Most of the surviving spouses I meet with have no idea, because the Veterans Administration isn't real open and upfront and advertising these benefits very much. So the amounts that you can get on a monthly basis for a veteran who is a single veteran, not married, is $1,911 a month to help pay for in-home care. If it's a married veteran, it's as much as $2,266 is the maximum amount. And for a surviving spouse, the maximum amount is $1,228. So it could be a benefit that's just enough to be able to keep you at home paying for more care rather than having to move into an assisted living or nursing home. Next is reverse mortgage. The reverse mortgage is that the HECM loan, it's home equity conversion mortgage. It's not like your typical one where you refinance your house, or you take a equity line of credit loan and you have to make payments back on a monthly basis. The reverse mortgage is a little different. You borrow money from the equity in your home, and you can take it out in a lump sum. You can take it out monthly. You can just have a checkbook to write against it. The big difference with the reverse mortgage is you don't have to make monthly payments. A lot of people think that the bank then owns your home and takes everything when you die, and that's not true. They will only lend you so much of the percentage of the equity in your house, because once that house sells, that's when they get paid off. They want to make sure that there's enough equity in the house, even if the value of the house drops, that they'll still get paid back. So you're never borrowing 100% of the value of your house. They won't let you. And when you die or when you leave the house, within 1 year, it's got to be paid off. Usually that means you sell the home, the loan is paid off, and whatever equity that's left in the house goes to you or goes to your children if you've died in the meantime. So I've had a couple clients, one lady who broke a hip and really wanted to stay at home, and she had not a lot of money, so she took a reverse mortgage out to pay for her household expenses and to pay for help in her home. This isn't going to help if you're going to a nursing home, because you have to be in your home to make that mortgage and to get the payments, and without having to sell the house and pay it off. Finally, long-term care insurance. I have very few clients who have long-term care insurance, but it can help you. It's like you buy a policy that says if you need home health care, if you need nursing home care, that it's going to pay you so much per month to help you pay for that. And they usually are in certain terms like 3 years, 4 years, 5 years, things like that. A lifetime policy is very expensive these days, so I don't see too many people with that. These are just options that you'd have to explore if you're worried about long-term care problems and you're trying to stay at home. The one fallback for most people is Medicaid program. It does cover long-term care. You have to need it on a health-wise basis. You have to have the need for help with 2 or 3 out of 5 or 7 activities of daily living. That's typically eating, dressing, toileting, transferring, continence, being able to take pills, dementia, things like that. You have to need the care. In nursing homes, this is kind of a telling tale. Only 40% of residents in nursing homes are actually getting Medicaid. Everybody else, for the most part, might have some VA help, but they're paying out of pocket. Or they have long-term care insurance, but all of those other ways kind of end. At some point, you'll run out of money. At some point, the long-term care insurance is going to be done. So then you'd end up on Medicaid no matter what. This is a federal program, but each state has to follow the federal law and set up their own program. And the problem with Medicaid is state programs differ. I can't tell you what New York or Pennsylvania or Illinois does with the Medicaid program. I can tell you what Ohio does because the plans are somewhat different. And also the scary part is they're even different by county. Cuyahoga County has slightly different requirements than Summit County or Lake County. So we have to try to keep track of all of these different programs. And there's Medicaid available at home through what's called the Passport program. There's also something called PACE, P-A-C-E. It's similar to the Passport program in providing care at home, but there are some differences, and it's worth investigating each of those 2 programs to determine whether or not there's eligibility. There's also Medicaid at some, but not all, assisted living facilities. And then there's Medicaid definitely in the nursing home. I don't know of any nursing homes who don't take Medicaid, because at some point people run out of money, and if they can't go home and they're in the nursing home, it's the only way they get paid. So there are some very specific income and asset rules. First page here, we're talking about for single individuals. For income, it used to be, up until a couple of years ago, that as long as your income was less than what the nursing home cost, that you'd qualify for Medicaid. But now they've made it a little bit more complicated. If your gross income happens to be over $2,349, then you're not, quote, eligible because you have too much income. But the way you fix that is setting up, I have here QIT, that stands for Qualifying Income Trust. You have to set up this special irrevocable trust and run your income through it in a special way, and then you become eligible for Medicaid. So it's one of the complications that make it difficult to get through the Medicaid application and eligibility process, because people don't know about it. Out of your income, whether you have a QIT need or not, you are allowed to keep certain amounts out of your income, something called the personal needs allowance. That's $50 a month that you get to live off of. If you have health insurance premiums, like for supplemental insurance or prescription plans, you get to keep money out of your income to pay for that. And the last thing that's there is past due medicals. That means if you've got some medical bills you ran out of money for paying, there's a way through your income on a monthly basis that it can pay off those old medical bills. Now, the income eligibility, we've got this problem. If you have your too high of income you have to deal with, you get to keep a certain amount out of your income to pay these specific items. And then the rest of your income, if you're in a nursing home, the rest of your income is your patient's share of cost. It goes to pay the nursing home. And then Medicaid is paying a per diem amount. Assets are also a problem. For a single person, everything's an asset with a few exemptions. So you get to keep a car, you get to keep a cemetery plot, you get to keep an irrevocable funeral contract, you get to keep your personal items. Other than those things, you can't have more than $2,000 in a bank account as assets. So you got to get rid of almost everything. Now, a house, they just changed the rules on houses. They used to say that if you were single and had a house and you haven't been able to sell it yet, they'll exempt it for a year before they make you sell it. That's gone. Now, the only way that the house can be exempted, if that's the case, you tried to stay at home and you paid every dime to stay at home and you couldn't do it, then if you still have the house, then you have to say, I intend to return to my home. So as part of the application process, it's just, there's no special form for it. You or your power of attorney writes a letter saying, Mrs. Smith intends to return home, so please exempt the house for now. So they will exempt the house, even though it's not supposed to be exempted, because you might go home. Now, if you stay in the nursing home the rest of your life and the house has been exempted and the car has been exempted and $2,000 has been exempted, when you die, you no longer need those things. So there's this really cool program with Medicaid called Medicaid Estate Recovery. And Medicaid Estate Recovery says, well, you don't need that car anymore for transportation. You don't need that house. You're not going there anymore. And you certainly don't need the money in your bank account. So now those things are subject to Medicaid Estate Recovery, and they go back to the state of Ohio to pay off the benefits you got in Medicaid while you were alive, up to the amount that Medicaid paid. So if you were only in the nursing home a few months, you'd still have assets left over that didn't all have to go to Medicaid Estate Recovery. However, if you were in the nursing home for years, like many people are, then everything might go to pay off the benefits that were provided to you, and there's nothing left for your family to inherit. So we don't like to have the house exempted by a I intend to return home letter, because at some point we got to deal with it. We got to deal with it, get rid of it before you die so that Medicaid just doesn't take it. And there's planning tools that we can use for that. Now I'm going to cover the rules for a married couple. It's a little bit different because there's two parties involved. But Medicaid looks at a couple as a unit, one person. For income eligibility, well, we've got two people now. How do we know whose income is whose? Because the income of the Medicaid recipient is the one that they worry about with being over $2,349 and need that qualifying income trust. The one who is at home still, they worry about that income because there are special rules for spouses still living at home. If their income's too low and they can't be above poverty line, then some of the income from the nursing home spouse gets to go to the spouse in the community to help bolster usually the wife's, because usually wife's incomes are lower, help them live and be above poverty line. So they employ something called name on the check rule. The name on the check rule is if the husband's name is on it, it's his income. If the wife's name is on the check, it's her income. So it used to be for married couples also that as long as the nursing home spouse's income was less than the nursing home cost, they would qualify. But the same QIT rules apply to the spouse in the nursing home, just like it does to a single person. If your income is over $2,349 gross, you have to set up this qualifying income trust and run your money through it in a special way. For a married couple, the one in the nursing home also gets to keep their personal needs allowance of $50, health insurance premiums that they might have to pay out of pocket, like for supplemental for drug coverage, past due medicals, just like for singles. And then there's MMMNA. It's the minimum maintenance, minimum marital maintenance needs allowance. That's the allocation to the spouse who's living at home to bring her income up to a poverty line level so that they're not having to lose their house and be in poverty. It's still not enough money to live very well on, but at least they do take that into account. So for asset eligibility, For a married couple, they look at everything either one of them owns. So it's husband's assets, it's wife's assets, it's joint assets. Even if that couple is on their fourth marriage and had signed a prenuptial agreement saying his is his and hers is hers, Medicaid does not recognize prenuptial agreements. They're still going to add up both the husband's and the wife's assets to see what their total assets are. So out of that pool of assets, which is everything they own, the exemptions for a married couple is one car, which is supposed to be in the community spouse's name, cemetery plots for both of them, irrevocable funeral contracts for both of them, their personal items, things in the nursing home, their clothes, things like that. Plus the house is exempt for a married couple automatically, as long as the spouse who's in the community is still living in the house. If they end up selling it, it's important to have the right timing on selling that in order to move into an apartment or a smaller place. But the house is exempt initially. Now, everything else, so it's bank accounts and investments and cash value of life insurance policies and the second car and a second home. And depending upon the situation, IRAs are looked at in couple of different ways, but generally they add up everything else and divide it in half. So if the couple has $100,000 of everything else, except these exemptions are not part of that. If this couple has 100,000, the spouse who is at home gets to keep half of that money, as long as the half of the money falls between $25,728 and $128,640. So if their total assets, aside from the exemptions, are 100,000, half is 50. So the spouse at home gets to keep 50,000 of those assets, and the other 50,000 has to be planned with or spent in order to achieve Medicaid eligibility. If the total assets that they have are $30,000 that are countable, half would be 15, but the government says that's too small an amount. That spouse at home gets to keep at least $25,728. And what if they had $600,000 worth of countable assets? Half would be $300,000, but that's too much. The most the spouse at home can keep is $128,640. So they've got more than half to plan with or spend or somehow get rid of appropriately to qualify for Medicaid. And like I said, there's planning tools. If you're single, if you're married, there's planning tools to plan far ahead of time. There's planning tools even at the last minute, but those are way beyond this basic kind of scope that I wanted to get into here today and talking about what you got to do just to kind of look at all of these issues that are going on. Okay, so what should you do? You need to have proper estate planning documents in place. You need a will. We talked about why. You need a financial power of attorney, healthcare power of attorney, and a living will. Those are the three for health decision making. You might need a trust agreement if you're trying to control assets after your death, and how and when and how much go out to your beneficiaries. The only way you can control that is with a trust agreement. Remember those other ways to set up probate avoidance: joint and survivorship, payable on death, transfer on death, naming a beneficiary. Those things go immediately upon your death, no matter what the situation is with whoever the beneficiary is. So if your son is right in the middle of a bankruptcy, inherits a bunch of money from you, it's going to be a part of the bankruptcy proceeding and help pay off his creditors. Maybe you don't want that, and you can set up a trust agreement for that child instead and try to protect that money. If you leave money to a child who's in the middle of a divorce, that could suddenly become an issue in that divorce, and you don't want that to happen. So a trust agreement can control assets after you've died. That's in a typical estate plan. We also use irrevocable trust agreements, which are different, like that qualifying income trust that you need for Medicaid. That's an irrevocable trust for one specific purpose to run your income through under the Medicaid rules. There's also an irrevocable Medicaid asset protection trust, which is sometimes how we'll try to transfer money to protect it in the end for Medicaid eligibility planning. There are special needs trusts that must be set up just so if there is a disabled child or grandchild or other family member that someone's trying to benefit without causing them to lose their benefits through Medicaid or through Social Security. So trust agreements have specific purposes, and we usually, if we're having a meeting with somebody, we'll go through, is there a need for a trust agreement? Sometimes there is and sometimes there's not. Now, these estate planning documents, that is not do it yourself. Filing a Medicaid application isn't really, even though it should be, it's not really a do it yourself process. Setting up these irrevocable trusts is not do it yourself, simply because if you blow it and it's irrevocable, you can't make changes to it. So that's a problem. That's why you need to have help with all of this. So on Medicaid, I was only able to really scratch the surface on how the rules work. You can ask the Department of Job and Family Services, that's the agency that handles Medicaid applications for the Ohio Department of Medicaid. You can look on the internet, but hopefully you've learned by this wise age you are that that's not necessarily a good idea. You can't always trust everything that's on the internet. And the caseworkers at the Department of Job and Family Services are not trained as extensively as would be nice, and they're overworked. And if you try to do a Medicaid application by yourself, it could easily get lost and sit on someone's desk for months. And if they don't look at it right away and you haven't done one of those qualified income trusts that are necessary, and they tell you 6 months later that, oh, we just reviewed your file and you needed this QIT way back when you applied, you'll lose 6 months worth of Medicaid coverage, because if you don't have that QIT in place, you're not eligible for Medicaid if your income is too high. So there's a lot of pitfalls. I would, just like you are listening to this webinar today, understand the rules, start planning early, seek information. I would recommend hiring a certified elder law attorney. Now, what that means is, for me, I've been doing this for 30 some years, but I had to take a test. I had to take a day-long test to prove that I was actually, I knew all of the laws and rules. And there's 12 different categories, including estate planning and probate administration and retirement and housing and taxes and special needs. And I can't even think of all 12 that there were. It's been, but it shows a level of understanding and proof that, this attorney understands how to handle all of these things, because, we're tested on it and we have to be recertified every 5 years. Come to our webinars and seminars, talk to your friends, but don't accept, Aunt Millie says she got Medicaid just by doing this, and why can't I do that? You don't know really what the circumstances are. So typically when we're meeting with somebody, particularly when it's an aging issue and potential Medicaid and stuff, we spend about 2 hours with the family to go over the family situation, what estate planning documents are in place, what's the goals here? What would happen if the husband went into the nursing home? How much would the wife be left with? What if somebody is a veteran and we're trying to qualify for those VA benefits that are available? They have their own separate rules on amount of income and amount of assets as well. So there's so much to go through. It takes at least 2 hours. Usually more if all the kids come in and all the kids have questions too, and that's okay. Everybody should, understand everything, but it takes a while. So you need to really dig in and plan, and you need to do it the sooner the better, because there are more options available before you get sick than if we're dealing with, oh my gosh, dad just had a heart attack and went to the hospital. Now he's disabled. He has to go to a nursing home to live. It's harder to plan then, just because it's too late to do some of the things that we might need to do in the future. So if you want to, set up a plan appointment, it usually takes, like I said, 2 hours or more. The cost would be $275. Just we flat fee everything that we can, because people want to know how much it's going to cost. We flat fee documents costs. We flat fee Medicaid application costs, because, we say up front, this is how much it's going to cost you. And, and therefore there's no questions. There's no worries about the fees and things like that. So last slide. Thanks for Zooming with me. I don't see any questions that anybody had typed in. So I hope that means that everybody understood everything. And let me stop sharing for a minute. Now it's me. I hope that it was helpful to you. Like I said, call the office. You'll be talking to Debbie. If you have any questions, if you want to set up an appointment at any time, we're going to be sending out the outline and the slides for this and some other information to everybody next week as a thanks for coming and listening to us. And now you can go out and enjoy your Saturday. So any last questions that anybody wants to post on the question and answer? Oh, thank you. Whoever that was who said great info, thanks. You're welcome. This is what I do, and I like to do it, and I like people to have information that is necessary. So in any event, you can go now, enjoy your mentioned references. Okay, somebody said you mentioned references for Medicare supplement advisors. Can you share those resources? I can. Not everybody. Is it okay if, because I don't have them rattling off the top of my head, I will have Debbie, when she sends out everybody's email next week, to thank you. I've got a couple people that I can just have, send those out in the email if that's okay. Okay. And somebody else said that would be great. Excellent. All right. So this is how I had to get you talking, huh? I needed questions. I wanted questions. Now it's not till the very end. So, but in any case, if we end this, you still have more questions, my contact information is there. You can always call the office and set a time to meet if you want to go in a lot more depth than we're able to in something like this. Oh, do IRAs affect Medicaid? IRAs do. I mentioned that the rules had changed a little on IRAs. It used to be, up until just a few months ago, that if you had an IRA, it was a part of your assets and you ended up having to liquidate it, spend it, or paying the nursing home or whatever with it, but it had a tax cost. Now they're changing things with IRAs, and it's not completely done, these changes. So we're not 100% sure how it's all going to play out. But so far, we know that if you are in pay status, that means you're over 70 and a half under the old rules. Now it's 72 to start taking your required minimum distributions. If you are in pay status like that, they don't count the underlying IRA asset. They count the income as a part of your income, which is likely to put your income over that $2,349 cap and cause a qualified income trust. That would be necessary. And your income would be going each month to the nursing home. But the problem with that is they don't count the underlying IRA while you're alive and getting Medicaid. But when you die, that suddenly becomes an asset again for subject to Medicaid estate recovery. So they get you coming when you're getting Medicaid monthly, and they get you going because you got money left over that can be used to pay the pay Medicaid estate recovery back for the benefits that you got. So it's a lot more complicated now than it used to be. When it was just an asset, we knew what to do. Now that it could be an asset or it could be an income stream, and we're weighing the best way to handle things for that in the future. Depends upon whether you're in pay status or you are not, and does it make sense to liquidate it anyway, because they're going to come and take it at the end in any event. So there's a lot to do with IRAs. So that's a whole nother seminar in and of itself. So any other questions? Okay. Will beneficiary get IRA? Same person, additional question. The beneficiary to that, the official beneficiary to that IRA would only get what was left over after Medicaid estate recovery took enough back to pay off whatever Medicaid paid during the lifetime of that person. So maybe and maybe not. It depends. If you're on Medicaid for 10 years, chances are whatever you got left in IRAs under these new rules, or your car or your house or whatever it is going to be gone because Medicaid paid a lot. If you're only in for 5 or 6 months, it may be there's very little to pay back, and the payback comes from a life insurance policy or something instead, and then the beneficiary can get the IRA. It's getting really complicated with IRAs. So, all right, last chance. Because we're a little past our hour, although I really didn't start until 2:05, so it's 3:05, so we're okay. All right, I don't see anything else. So I thank you for attending. Let us know if we can help you in any way, and please come back to additional webinars. This is it for this year, because we're going into the holiday months and stuff, but we'll start it up again in January and February, and I hope that at some point we can get back to in-person ones, because I really like to talk to people in person rather than just online. So I appreciate you coming, and I'm going to end this call, or Zoom, or whatever you want to call this, right now. So thanks a lot, and hopefully we'll see you at a later time at another webinar, seminar, or at a meeting. Thanks. Take care and have a good rest of the day.